Welcome to the Protect Your Nest podcast, hosted by me, Attorney Brandon Lawrence. Here, we're taking the mystery out of estate planning and probate with honest conversations that make complex topics easier to understand. Everything from wills, trusts, healthcare directives, and elder care planning. It's all about helping you make the informed choices for yourself and your loved ones. Let's talk it over. Hey everyone, welcome to another episode of Protect Your Nest, where we discuss estate planning for you, your family, and your legacy. I'm estate planning attorney Brandon Lawrence, the lawyer for the city. We are discussing wills today. I'm going to give you some tips on what to do to make your will simple and effective. I previously talked about getting financially eligible to have Medicaid pay for your long-term nursing home stay, and using wills and trusts to protect your assets for your family to use after you pass away. Today, I'm going to give you some tips on what to not put in your will. First of all, in Kentucky, you can write your own will. They call these holographic wills. There are rules and regulations you have to follow in order for a will to be considered legal and valid in Kentucky. In order for the holographic will, which is what they call it, to be valid and legal, it has to entirely be handwritten in your own handwriting. Secondly, it has to be signed and dated. You don't have to have a witness to this will, but after you die, someone familiar with your handwriting has to testify that the will is entirely in your handwriting. And this is all covered in the statute, which is Kentucky Revised Statutes. I think it's 349.040. And I wanted to get that information out there because some people, they like to write their own wills. And they like to be precise and have everything in there, and definitely in their words. And these are the rules that you've got to follow for what they call a holographic will, have it entirely in your own handwriting. So I took a little detour for folks like that. Now let's get into what not to put in your will. Okay. People come into my office a lot and they say, hey, they've got things written down on what they want in their will, what they want in their planning, trust, things of that nature. And that's perfectly fine. That's awesome. That's great. That shows that you've done a little bit of prep before you've actually come into the office. You might have Googled, ChatGPT, whatever you wanted to do, and decided to come in the office after I've gone over in previous episodes. I've met with people either in person or via Zoom. You filled out the intake, told me kind of what your wishes, what you wanted to do and leave for your family, and you've expressed that, and we're sitting down actually either via Zoom or in person to make everything that you want to happen, and tell you what I can do for you as far as your estate planning. So what you want to do is, one of the things, I'll just give you a couple examples of things that people come in and say that they want to put in their will. And like I said, it's not a bad thing, but I'm going to tell you a couple things that you probably do not want, well, you definitely do not want to put in your will. Now, one of those things are everyone's working, you got a IRA, you've contributed to it, your job's contributed to it, or either you and probably you have put a percentage of your earnings in that IRA. But when you fill that IRA out, you probably already named the beneficiary when you open your IRA. So that's one thing that you do not have to put in your will, because that beneficiary designation that you put in the IRA, that's going to take precedent over anything that you put in your will. So you don't need to do that. If you want to, I guess you can, if you want to switch a beneficiary up, you can contact the IRA financial institution or your job and do it that way. But the will is not going to supersede the IRA beneficiary that you've already put in place, and you probably put that in place years ago anyway. So that's one thing you don't want to put in your will. Nothing to do with the IRA beneficiary. So another thing, funeral arrangements. We talked a little about funeral pre-planning funeral arrangements to get eligible for Medicaid in the previous a previous talk that we've had. Now, in this particular instance, when you're talking about wills, you don't want to put anything about funeral arrangements in your will, as far as, if you want to be cremated or buried, that type of situation. Because, say, for instance, if you've got, you pass away, you get buried, and you read the reading of the will doesn't occur until maybe weeks later. So then when people finally read the will, and you said, I wanted to be cremated, then the family's probably got a decision to make. Are they going to dig you up and then cremate you, or, are they going to have to live with the fact that they did not comply with your wishes, even though they didn't see that until afterwards? So what you probably want to do is make a separate document to express what you want done as far as your funeral arrangements, informally or formally, to a family member or whoever that you're trusting to deal with, to make those arrangements, so they'll know that when that time comes for you to be properly put away, whether you want to be buried or cremated, whatever you want, and they comply with your wishes. The other thing and that's two. That's the funeral arrangements. That's the second thing. Now, number three, organ donation. Organ donation is a really big deal, because a lot of times, people are interested in donating their organs if something happens to them, if they're able to donate to another individual that's going to need them when they're no longer able to use them, they pass away. So whatever the circumstance is going to be, because that's extremely important, because there are a lot of people out there on organ donation lists that, that need certain organs that can be donated. So the organ donation is something that you want to do and make a decision and make your wishes known before you pass away, obviously, because if they're going to bury you or cremate you, then there's nothing that could be done. So you want to make those wishes known to someone prior to you passing away. So there are several ways to do it. I guess you can, I know when you go to renew your driver's license, you can check a box, and they'll put a heart or something on your driver's license to show that you are an organ donor. So that's an important situation that you want. That's an important thing that you really want to make known prior to you passing away. So that's three, organ donation. The fourth thing that I would say would be life support machine wishes, right? Because as I previously stated in in previous videos, obviously we don't know how we're going to pass, and we don't always instantaneously pass away. It's not always a car crash or something, and that, instantly you die. Sometimes, your life can be prolonged by a life support machine, ventilator, thing like that. So what you want to do is make that wish known. Some people would like to maximize and try to live as long as they can on the machine. Some people are of the opposite opinion. They say, hey, look, if I cannot be myself, if I'm going to be a burden, I'm going to rack up a huge medical bill, and I'm not going to know what's going on or be able to function, I don't want to have, have a machine keep me alive. and that's fine and good. But what you probably want to do is express that through a living will, not necessarily a last will and testament. Okay, and also we'll go to the next thing. The next thing will be a trust. We talked about trust as well. So once if you put your assets or property, like your home or any type of money, monetary gift that you want to bequeath to you want to give to someone, make them the trust beneficiary, that is going to take precedent over any type of will. So the trust is already set pretty much while you're living. The will's not going to take effect until after you pass. So, but by that time, the trust is going to dictate where any type of monetary gift is going to go, or any property that you put in that trust, and you fund it properly. So that's another thing. We talked about that before, properly funding a trust. But the trust is going to take precedent over anything and everything, including the will. So make sure, I'm telling you these things to make sure that, number one, make sure that you got this, that the trust that you open has got everything that you want in it, and you're giving who you want everything to go to. You make sure who you're giving that to, or is set to go to, that's who you want it to go to at that particular time, because a will is not going to invalidate that trust. So a lot of people have, but on another note, the next one is going to be a LLC. Okay, the LLC, you can the assets in the LLC are governed by the LLC. So a lot of people have property, real property, in their LLC, real estate, right? You might have a couple pieces of property, and you might have them titled, all titled. Say you've got 4 or 5 properties, you title them in an LLC, all right? But upon your death, you want to give, you want to divide those properties and give them each individually to a particular person. Now, it's difficult to do that in a will once you have those properties in the LLC, because the assets are going to be governed by the LLC. You can't really just say, hey, I want to give John my property on 5th Street, but that's titled in the LLC with 6 other properties. So there's a couple ways to get around that. To just not get around, but to deal with that. What you could do, you could retitle all the properties into individual LLCs, and you could leave a membership interest to John or whoever you want to leave that to. All right, you can leave the you can leave the membership interest to specific individuals, but that's one way to deal with an LLC situation. All right, and going and also along the lines of a trust or going back to the IRA, life insurance policies. A lot of people have life insurance policies that you've already designated beneficiaries to when you took out that life insurance policy. So the designated beneficiary the beneficiary you designated when you took out the life insurance policy, they take precedent over any will beneficiary designation. All right. So again, make sure that you should check your documents every few years, and make sure that you still want to give that you still want to leave those assets and make the beneficiaries that you have designated already. If you want to keep those people as your beneficiary, then you can stick with that. Or if you want to change it, you've got to go through the proper channels to change those policies or those designations. And the last thing I would say would be, when you're going to leave something to someone, okay, say for instance you want to leave you want to leave whatever you're going to leave to somebody, I would say brevity is the key. You don't need to write a book or a novel to explain why. Say, for instance, you're going to give something to your niece. You're going to give something to your niece because she took care of you. Because she brought you food, she took you to the movies when you were bored, things like that. That's fine. That's awesome. You can tell that to her. You make a video or something, or tell it to her personally. But the will is not the place to put that to explain why you're going to do something for someone. You don't have to do that. You just give it to them, and then make sure everything is signed, documented, witnessed, and filed. So those are pretty much approaches. It's pretty simple approaches that you want to take in order to make your wishes known and make sure that your wishes are follow through with. And I wanted to just reiterate if you're looking it up, the KRS that I was talking about is, I think I said it was 394.040, but I just wanted to make sure that you got that. Because like I said, people come in all the time. I'm more than happy to sit down and talk with you via Zoom, in person, come to your home. As a matter of fact, a few weeks ago, I just went to some folks' home, and they wanted to, they wanted to take care of some things as far as leaving some houses, some real estate, and some money, and they had some decisions to make as far as who they wanted the trustee to be. And they wanted originally they wanted co-trustees, and we talked about options and what may be the best thing for them. And they had some decisions to make as far as who they wanted to be as the trustee, what they wanted to leave, and they ultimately came to a decision, and we documented that, and they were happy with the outcome. So it's that's the best thing to do. Like I said, the best part of my job is sitting down with people, talking to them, and making what they want to happen, making that happen, and explaining to them the process. And like I said, a lot of people come in with some prerequisite knowledge, and they come in, they looked at some videos, they've YouTubed some stuff maybe, or looked at some podcasts, which you can always check me out on the lawyerforthecity.org, and look at these podcasts, and also look on YouTube. And that, all the more information that you have is fantastic. And I'm here as a roadmap to help you get down the road to get where you want to go, and take the knowledge that you have, excuse me, and the experience and knowledge that I've got, and help you get to where you want to go. So you can always find more information that I'm putting out all the time. Like and subscribe on the YouTube channel so you can always get information, and look at old videos that I've posted already to answer any questions that I might not have gone over in this one. And we're going to continue to try to give you information all the time, and get you where you ultimately want to go, to make sure that you're protecting your nest. And until the next time, it's State Attorney Brandon Lawrence. Let's talk it over. That wraps up today's episode of the Protect Your Nest podcast with me, Attorney Brandon Lawrence. I hope you picked up a few ideas to help you and your family plan with confidence. Be sure to like and follow so you won't miss our next conversation, where we'll continue exploring the topics that matter most for your family's future. Until next time, let's talk it over.